Hello guys, my name is Jeannie JF. I'm CEO and co-founder at Starbucks as well as in RWA Media. And today I would like to speak more about the regulatory risks of the tokenization and what are the legal or regulatory nuances of issuing and managing a tokenized asset or RWA. So first of all, it's very important to distinguish between real world assets, right? And compliant assets, something that you hold, with anything from the crypto space. So again, a mem token won't be a real world asset, right? Or just a picture drawn on the Photoshop and NFT'd through open space won't be RWA or real world assets. So what we're talking about is why they're real world assets, because these assets exist in the world, right? So there's a cup, there's a computer, laptop, real estate, anything. So anything in the real life is a real world asset. And when we say that we want to tokenize, what does that mean? It means that we have the custody of that asset, right? And then we assign the ownership of that asset to the specific contract, right? Or we transfer this to the blockchain. So when you have an asset, right, under custody, by tokenizing, what it means is that you transfer the records of the ownership of that specific asset to the blockchain and represent it in the form of tokens, right? You can have tens of tokens or tens of millions or billions of tokens. It depends on the different nuances of that specific issue, of that specific project. But the asset, for example, this cup, right, can be transferred to the blockchain and tokenized in a form of millions of tokens, of 1 million. So whoever holds a token, right, would hold the right of a 1 millionth to that specific cup. So that's how tokenization of real estate performs, or private companies or any company's tokenization. So when you tokenize an asset, it's important that you have a legal contract between the asset, right, the issue of the asset, and the blockchain itself. And it's, if a company doesn't show the transparent ownership of the physical asset transferred to the blockchain, it means that there may be some regulatory constraints or some legal constraints. So if you research for RWA, if you look for a tokenized asset, first of all, look at the legal aspect. What does that token physically represent? What is it a part of? What is the legal connection between the token and the asset that you're buying? Because if you're investing into the RWA, basically you are buying a part of the physical asset. So if it's an asset without the custody, right, or if it's an asset which can be overvalued, you may have certain risks. So it's very important for you researching on the RWAs is to actually look for the legal nuances and see if everything goes fine with legal and regulatory. The next point within the regulatory or legal risks with the RWAs, it's important to acknowledge that most of the cases, 99% of those cases, the tokens that represent the real asset, right, these tokens, they have to be connected to the identity. So they have to be KYC'd. So it's not like on any decentralized trading when the anonymous trading is allowed or performed. With the tokenized assets, at any given time, the owner of that specific asset has to be seen, right? So who is the person that holds that asset in a specific point in time? So KYC is very important issue. And again, if you go around and you surf and you see RWAs without any KYC backgrounds or without any legal recognition, right, I would suggest doing a very, very thorough additional research on that kind of assets, because they might bring risks, right? Again, KYC is an important aspect. The third aspect is the AML, the anti-money laundering laws. There are already existing AML laws in the digital assets, in the crypto space, right? But it's very important to acknowledge that those, and moreover, securities AML standards are imposed for RWAs. So if a company, an issuer, does not perform an AML check on their investors or KYC checks, or fail to show the legal grounds of that specific asset, I would suggest that's a lot of red flags with that specific asset. Next point with the regulations and with the compliance of that specific asset is how it's being offered, how it's being sold. And that's actually, it's a very tricky question, because there are a lot of jurisdictions. I would suggest, let's say, there is a US legal system, there is EU legal system, and let's put it this way. And there's different legal systems in Asia, in Asian countries, in Korea, in Japan, in China. So there's, every country has their own securities legislation. Most of the countries have their own securities legislation. So when the tokenized asset is being offered to the public, it means that the principles and the legal procedures of that offering has to comply with an existing offerings legislation of the country of the issuer. So if you're raising funds and you're creating a company in US and you're offering your US based security token to the general public, you would have to precisely understand the landscape of the SAC offering memorandums, how you can offer that security token, tokenized asset, from United States if you're a company that issued, right, an asset from United States. Or, for example, if you're running an EU company, or if you're running a BVI company, or if you're running a Singapore company, or Maltese company. So all of these jurisdictions, they primarily have this set of laws how you would offer these types of tokenized assets to the public. And if an issuer, for example, fails, right, to comply with this securities offering, so that might create severe risks for the issuer itself, because it's not only the process of creating an asset, right, that is interested by regulators, right? We create an asset, but it's also important how you offer them to the public. So if you offer these assets as if they're mem tokens, for example, through the Uniswap without any KYC, AML, if you see those type of RWAs, I would suggest there's a lot of red flags, right? So this is something that we should know, that this has additional risks. On the other hand, if you see that an issuer created an offering memorandum, it refers to the regulated documents and explains to investors what is the asset that investors buy, what are the terms of the purchase, what are the risks, what are the conditions, what are the disclaimers, what is that legal contract that you as an issuer are offering to your investors in return of their money, and what are the risks of that. If you guys as investors don't see that approach from issuers, again, I suggest there's a lot of red flags with that specific company or that specific asset. On the other hand, if you see that the RWA has KYC standards, AML standards, privacy policies, has a lot of, all essential documentation, has PPM, which is a private placement memorandum for United States, or prospectus in case of Europe, you see that all these documents have been prepared, there's risks, there's disclosures, this issuer is on the right track. Of course, you have the right to ask all of the questions, but I would just suggest that this kind of projects, this kind of RWAs have much more green flags, right? Again, this is not call to action. You don't have to invest. But again, by looking at those two differentiations, KYC, AML, offering memorandums, how legal is that? That would remove you from the multiple risks that you could face by investing in a non-compliant, non-regulated security tokens or tokenized real-world assets. So speaking about the regulatory and compliance risks, I told you from the investor side, look for those type of documents, look for those type proofs, do your own research, don't give your money to anyone that says RWA, because we look at the market. Market is skyrocketing, right? We see from all the Twitters, from all the Telegrams, from all the news, we see RWA is moving, is growing. A lot of crypto people are just, that narrative expands, but you have to stay clear mind, you have to be calm, and you have to understand that if those criteria are not met, you have to do additional research. So that's important. In respect to the token issuers, I know, guys, that may sound a bit complicated, but we at Starbucks have spent 5 years working in this field. We pretty much know how assets could be, should be, have to be tokenized, what are the pitfalls, what are the risks, what is the best jurisdictions to frame those tokens, to create those tokens, what would be the exemptions or regulations to offer those tokens to what type of investors, global, local investors. So all these questions, we mostly have all these answers for. So if you want to issue your own asset, if you want to tokenize something, nothing stops you from going to the Starbucks IO, go to the contact, schedule a call with one of our leading specialists, and we will explain you all. You will be able to create your own asset with all the respect to legal and regulatory procedures. So come to Starbucks, contact us, we will answer your questions, whether or not it's a tokenization of real estate, if it's a tokenization of private business, or if it's a tokenization of something else, anything that you think, write to us, we will come back with some sort of idea, and then you see if it's feasible for you. But you have to know that you can't fast forward that process. So tokenization is a legally recognized process. So let's respect this.